a very timely discussion on the crime of ecocide. You, our audience, number, well, at the moment it's bang on 200, but I think more are coming, certainly more are registered, 260 in all. And you're made up of students, members of the Inns, and the general public. The purpose of this series of social context of the law talks is to enhance an understanding of the law and its social importance. And we do that through the open discussion of difficult questions that the law is asked to address and concerning which there may be equally plausible but conflicting views. Now, before we start, a few housekeeping points. This lecture is being recorded and it will appear on the Inner Temple website in the coming days. A link to the talk will be sent to all of you afterwards. If you have questions, please use the Q&A function. As many questions as possible will be put to the panel at the end of the discussion, subject to time. And we are scheduled to finish at about 7:15. So on to our speakers. We are extremely grateful to our distinguished speakers for giving their time to discuss what is one of the most important issues facing us today. We have two, Professor Philippe Sands, QC, barrister at Matrix Chambers, Professor of the Public Understanding of Law, Faculty of Laws, UCL, Samuel and Judith Pizar, Visiting Professor of Law at Harvard Law School, co-founder with our other speaker, James Cameron, of the Centre for International Environmental Law in 1989, and its UK successor, FIELD, the Foundation for International Environmental Law and Development. Professor Sands co-chaired the panel that drew up the definition of the draft law of ecocide, that is to say, unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Now, you will appreciate that there is a huge amount more that could be said about Philippe, but let me move on, otherwise this will be all my introduction and none of the principal acts. James Cameron is an international lawyer, policy advisor, and social entrepreneur, so an advocate in the broadest meaning of the word, who champions ideas and challenges those in power to bring about change. His work is centered on the issue of climate change and its impact on humanity and the natural world. And as well as co-founding the Center for International Environmental Law and the Foundation for International Environmental Law and Development with Professor Sands, he is senior advisor of the Foundation for International Law and the Environment, a fellow of the Yale Center for Environmental Law and Policy, and advisor to the UK presidency of COP26. So, ladies and gentlemen, those are our speakers, but of course we're joined by Sir Geoffrey Nice, QC, who is chairing this evening. Geoffrey, welcome, and over to you to say a few extra words before Philippe and James get going.
Well, first of all, apologies to everyone for delayed start, which was a result of the fact that for some reason my computer wouldn't link, and it took Kate Peters to ensure that eventually I joined you. Thank you very much for the introduction, Guy, and thank you, Philippe and James. I have nothing to add to the introduction, save only to say that the urgency of these matters under consideration no longer allow for the passage of time. The audience will be interested to note that you two were alive to all this in 1989, when it was possible to deal with it in a leisurely way. James, fresh from COP26, and Philippe always, but most obviously recently, knows full well time is not on our side. And so one of the really interesting issues with which I will end these few observations is the law going to be able to work fast enough, or do we have to think of alternatives? And I think, Philippe, you get the first. It should have been 15 minutes, but I probably cut it down. Off you go.
Let's. I think, Geoffrey, it's so lovely to see you, and I want to thank Inner Temple and Guy and James for the opportunity to be on this conversation. It is a really important conversation now to be had. James and I were indeed, he can say more, he's much more abreast of what's going on in the particularities of climate change, so I'm going to leave that to him. But we were there in 1989 at the Second World Climate Conference. Remarkably, we both sat behind Chris Patton when Margaret Thatcher addressed the cast of characters. It was that long ago. I remember it incredibly well. We saw President George H.W. Bush address the first negotiations at Chantilly. I won't ever forget that. It's extraordinary how we have in effect squandered the 35 intervening years or so, or the 33 intervening years or so, and left ourselves now with so much to do and so little time. And both James and I, in our different ways, have addressed the question of what is the function of the law in addressing these issues. When I studied international law, the word environment did not feature. I remember having a spirited conversation with the late, great Ian Brownlee, Professor of Public International Law at Oxford, in 1991, when I said, Ian, why don't you put the protection of the environment into your famous textbook, Principles of Public International Law? And he just looked at me and he said, because it doesn't exist. It's not part of international law. That was 1991. And I said, well, when will you put it in? There's loads of treaties and there's some limited cases. And he said, I'll put it in when the International Court of Justice says it's part of international law. Well, 5 years later, I had the privilege of acting for a number of Pacific Island states in various nuclear cases at the International Court of Justice. And lo and behold, the International Court of Justice, in its advisory opinion on the legality of the use of nuclear weapons, ruled that the protection of the environment was now part of the corpus of international law. And I give great credit to Ian Brownlee. 2 years later, a massive 4 pages on a 1,000-page treatise was inserted into the famous book, and that opened the door. A lot has happened, of course, since then. Let me focus a little bit on the subject of ecocide and just give a little bit of context, and James can, I think, then fill it out and put it into the broader context, in particular in relation to hugely significant developments of COP26, which he played a central role in. The idea of ecocide has been around for some time. It was first evoked in the late 1960s in the context of the Vietnam War and the use of Agent Orange. And an American academic, professor of sociology, I think, was the first to use the term ecocide based on the concept of genocide. Word of background here, since 1945, there have been 4 international crimes. And Geoffrey, I do apologize, you know this better than anyone in the whole world, so forgive me if I do a quick reminder. There is the classical war crimes, which dates back to the 19th century. And then in 1945, in the context of the Nuremberg trial, 3 new international crimes created in an instant in London in that summer of 45. Crimes against humanity, the protection of individuals, the concept of genocide introduced into the indictment in October 1945, the protection of groups, and what is today called the crime of aggression, the waging of illegal war. And since 1945, those have been the only international crimes of pertinence, all, of course, incorporated into the statute of the International Criminal Court in 1998. And those who are watching will understand that all of those crimes, for very good reasons, focus on the protection of the human being in different ways. They are not concerned with matters of cultural protection or environmental protection, because when they were invented, those matters were not at the forefront of the consciousness of the drafters or of states. But over time, that's changed. In 1972, the Prime Minister of Sweden, Olof Palme, in his opening to the famous UN Conference on the Human Environment, evoked the idea of a future crime of ecocide. There were various efforts in the 80s. In 1998, actually, I was in Rome with my good friend Andrew Clapham. We drafted the preamble to the statute of the International Criminal Court. And there was a move to include environmental protection, but it was felt that it was premature at that point. And if you're creating an international criminal court, let's stick with what we know. And their matters rested until the remarkable Polly Higgins came on the scene. And almost single-handedly, delighted to say, member of the English bar, evoked and ran with this idea. And frankly, she was in the wilderness for many, many years. And even I must confess, was pretty skeptical about whether the time was right, perhaps because environment was so recently into international legal consciousness. And so I watched with great interest, and I suppose from a distance was supportive, but questioning of whether the time was ripe. Sadly, she passed away 2 or 3 years ago, and the struggle has been now taken up by the marvelous Jojo Mehta and a large group of people around the world. It has to say it is a global movement to put into the statute of the International Criminal Court a new crime which would protect the environment. They've given it the name ecocide, and I'll just say a little bit about that. It's relevant to explain. Geoffrey, we had an exchange of emails. The Stop Ecocide Foundation, that has been really pushing this exercise, did market research like any sensible early 21st century institution. And what they encountered on the streets of the world was that if you talked about environmental crimes against humanity, no one paid any interest whatsoever. What's that? Technical, legal, what does it mean? But the moment people were presented with the concept of ecocide, they were, oh yes, I'm totally against that. We must stop ecocide from happening. There is a magic in the word genocide, and that magic has been translated into the environmental sphere. And so when Jojo Mehta got in touch with me and 11 other colleagues with whom I had the privilege of working for 6 months on an independent working group to come up with the idea of drafting a workable definition of the crime of ecocide, the word ecocide had already emerged. And you've understood straight away, Geoffrey, that this evokes the concept of genocide, but we were all absolutely clear that we would not go, if you like, with the innards of genocide. For those who are not schooled in this world, the difference between a genocide and a crime against humanity goes in large part to the need to prove a special intent in the case of genocide, to prove the intention to destroy a group in whole or in part. And that doesn't work in relation to ecocide because no one intends to destroy the environment in whole or in part. The destruction of the environment is always the unintentional, incidental consequence of some other act, which is intended, no doubt, to produce some social benefit, economic development, cultural developments, or whatever. And so the very first thing that we did as a working group was to agree that obviously we had to stick with the term because it had developed a life of its own. But in defining its content, we were much more in the direction of crimes against humanity type of language. Just a word about my own engagement with it. I was contacted out of the blue. I'd had no contact with the Stop Ecocide Foundation. Would I be involved? Would I co-chair with a distinguished Senegalese jurist, Dior Sao Fallo? And I agreed to. I must confess, I overcame a degree of skepticism. Why? Because I think in the last couple of years, I've become increasingly and seriously, gravely concerned about the state of the environment, because I believe the exercise of criminal law will not magically suddenly transform things. And if we have a crime of ecocide, all of a sudden everything will get better. But because I do believe in the power of the law, including international law, to change consciousness. And that the adoption of a freestanding international crime with the objective of protecting the environment rather than human well-being sends a signal which concentrates the minds of others. And that's a useful thing to do. A few years back, I had done an advice for, let us say, a tobacco company whose executives were anxious that they may, at some future date, be enmeshed in the crimes against humanity allegations in respect of their failure to come clean about the consequences of smoking tobacco, taking tobacco. And it was very interesting to learn that the one thing that really does concentrate the mind of an executive of a company is the fear of a tap on the shoulder. And that stayed in my mind. But more to the point was the reaction of my own children. I have 3 children, all in their 20s. And when The Guardian ran a report saying that we were set up and we were going to try to define a crime of ecocide, it's the first time ever. James also has children, and he knows we love our children. They're wonderful. But they're pretty skeptical about some of the things we get up with. And from each of the 3, on the same day when The Guardian reported what we were doing, I got a WhatsApp, which had never happened before, saying, "Oh, fantastic, Dad, you're finally doing something useful." And it was a generational thing, you know, the energy of younger generations, teenagers, people in their 20s, for the environment and for finding mechanisms really has reinforced my sense that my generation needs to be doing something about this. Let me say something about what we came up with. We were a group of 12 very disparate characters, I have to say, geographically disparate, balanced in terms of gender, sexual orientation, color, nationality, politics, ideology, which was exactly how it should be. There were deep greens, there were skeptics, a US federal prosecutor, an international, former international judge, across the spectrum of views, which was right. And we agreed at the outset that we would do all we could to proceed by way of consensus. We all know that a consensual document has greater weight and authority than one that is riven with dissents. And we all agreed we'd be willing to make the compromises that needed to be made. I was, I must say, deeply inspired by the work of Lauterpacht and Lemkin back in 1945 in coming up with the concepts of crimes against humanity and genocide. In the midst of the Second World War, learning that their families had perished, they didn't lie down in a corner and weep, curl up. They used the power of ideas to make the world a better place. And I think that's what all of us on the working group wanted to do. A number of points, I could talk at length, but I won't. I just want to make a number of key points. The first thing we wanted to do was to sever the link between the protection of the human and the protection of the environment, to come up with a definition that was not anthropocentric. And on the definition we've come up with, and Guy has read it out, ecocide means unlawful or wanton acts committed with knowledge. There is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. We did not want to make the crime of ecocide dependent upon proving harm to human beings. In other words, the destruction of a micro ecosystem or of the last remaining species of a highly valued species without showing proof of harm to humans could of itself be sufficient. Harm to humans could be a factor, but it would not be a necessary factor. Second point, we wanted to come up with something that was simple. We all know that less is more, and that the more complex our definition, the more likely it was that it would prove to generate resistance. And a third point, we wanted to come up with a definition on which we could point in respect to every word or idea contained in our definition to an existing international criminal law norm, so that we could say to the states that will have to run with this if it's to go any further, yes, the whole is new, but the parts all have support in precedent, because as we know so well, governments are extremely cautious creatures, deeply conservative. The international legal order is deeply conservative. And if you can show that it's been done before in another context, you've got more of a chance to run with it. And that is what we did on this definition. Fourth point, we had a tremendous battle in our group on whether to include a list of certain acts which could be characterized as criminal. And nearly half the group was absolutely adamant that we must do that. And a little more than half of the group strongly opposed it, myself included. I'll speak only for my reasons, for 2 reasons. Firstly, once you include a list, you exclude everything that's not on the list. And you, by implication, suggest that that which is not excluded is fine. This has been a real issue for me, and you'll understand this, Geoffrey, in the context of genocide, where the number and identity of groups that is listed in the 1948 Convention is very limited. Nationality, ethnicity, religion doesn't include, for example, political affiliation or sexual orientation. And that means that somehow acts motivated with the intention to destroy those groups are obviously not caught by the convention and somehow less bad. And that has been a real lesson for me in some of the cases that I've been involved in. But there was a second, perhaps more political advocacy reason for not doing it. The moment you have a list, you've got opponents to what you're doing, because you are effectively linking with corporations or governments that are particularly connected to certain acts. So, for example, if you're going to have a list, and James may say more about this, you cannot have a list which does not in some way include climate change. Okay, a list without climate change on is an absurdity. I was of the view that the moment you included climate change explicitly in this definition, the entire exercise is dead, because states will not accept through the back door the criminalization at the international level of something they've been trying to regulate for 30 plus years without success. And you can't have a list which doesn't include climate change, and you can't have a list which does have climate change in it. Therefore, there must be no list. And that view, in the end, I'm glad to say, prevailed. We took the view that, as with crimes against humanity in the old days, if you go back to the old Article 6, paragraph C of the Nuremberg Statute, a general definition, it will be for a prosecutor to decide whether a certain act does or does not come within the definition, and of course, ultimately for the judges to decide what to do with it. Let me stop there. We can come back to particular aspects and just finish by saying what has happened since we have come up with our definition. Well, who knows what we thought. I mean, we went into the enterprise in good faith, and of course we hoped that something might happen, but I could not have foreseen what has happened. I have had a large number of countries get in touch, mostly behind the scenes, but not only, and say, yes, this has to happen. I was invited, for example, within a couple of weeks to do a webinar for all the diplomats in The Hague by the German ambassador. The German ambassador does not organize webinars unless he's got some sort of a nod from Berlin that it is not embarrassing or inappropriate to have a conversation about ecocide sponsored by the German embassy in The Hague. And various political leaders, President Macron of France being one of them, openly, and others behind the scenes. I've had a private Zoom meeting with the relevant British minister who has said absolutely the British government will not oppose this, whether it comes out foursquare in favor when it reaches the Assembly of State Parties is another matter. We've had the Secretary General of the UN within a week of our definition coming up saying this has to happen, this is a good basis, and I totally accept that this is just a starting point. I'm not wedded to this definition. It's a basis for discussions. We've had the Pope, we've had many corporations. I've had a public Zoom with Swiss Re, the insurance company. I've had private Zooms with major corporations saying we understand this is going to happen and this must happen. And so I think there is now something that is going on. I was very pleased that last week the Parliament of Belgium, its Foreign Affairs Committee, became the first to adopt a resolution proposing two things. Firstly, that Belgium adopt an internal domestic law on the crime of ecocide based on the definition we came up with, and secondly, mandating the Belgian government to lead international negotiations for the amendment of the ICC statute to include a fifth crime. And this week it is expected the Belgian Parliament as a whole will adopt a resolution in that direction. So things are moving along. The Assembly of State Parties takes place in 10 days. We will do an official side event. There's tremendous interest, judging by the private emails I get from people in various governments, of all ilks and of all colors. That's what's quite interesting, actually. It's not a sort of party political left or right thing. It's extremely interesting. And I would say the situation now is not whether this happens, it is when it happens and how it happens. Whether it's 3 years or 5 years or 10 or 20 years, who knows? But I have no doubt that there will be a crime of ecocide on the statute of the International Criminal Court at some point. I am not starry-eyed about what that means when it comes, but I think it's an important nudge in the right direction for recognizing that our responsibility to protect the global environment includes a responsibility backed by force of international criminal law. Let me stop there, and of course, happy to come back with more questions and conversation in due course.
Philippe, thank you very much. The history generally and your personal experience probably settles many of the concerns that I had and expressed very thinly in my email to you. I remain interested to hear, perhaps later, whether you really think that this form of a statutory genocide can be dealt with any more swiftly than the extremely troublesome criminal genocides that often take a decade or more to get to conclusion. But we must turn rapidly to James, but just before we do, to everyone else, we will deal with as many questions as we can. They have to be put in the Q&A box. The shorter you make them, the better, because the more people will get a contribute to ask questions and have them answered. James.
Well, thank you very much. Thank you all for attending, and thanks to the Inner Temple for putting this on. And what a delight it is to be with my old mate Philippe talking about this topic, and also to remember Polly, because I do remember very vividly Polly Higgins coming in to, even way back in our old offices, Philippe, Centre for International Environmental Law in Manresa Road, long time back, and her setting out her stall, trying to persuade us to really take this idea up. And I, like Philippe, but not sure that we really could commit to this, the strength of this idea then, when we were so focused on getting these new agreements up on climate change, for example, which provided such a strong focal point for all of our work. It wasn't just actually climate. The Biodiversity Convention was being born around that time. There's a huge amount of effort before the Earth Summit in Rio in '92. Ultimately, we didn't get that forest convention that we had drafted on behalf of the EU and the Netherlands. I remember we got the forest principles, but there's a massive amount of effort going into international lawmaking on the environment at that time. And I didn't think that ecocide and the agreement that she had put it in, it wasn't just a single concept, she'd put it in a kind of international criminal agreement on the environment, was the right approach. And insofar as there were crimes to be discussed, I was more interested in national courts and tribunals being the place to bring them, and using existing rights arguments, including, of course, existing human rights. So I remember vividly the classes that we took in the LLM program that we taught. The classes on human rights in the environment were always very vibrant. There were fantastic contributions in those classes from people who were thoroughly engaged in the possibilities that existing human rights law had when directed at the problem of the environment. And it allowed all sorts of avenues of inquiry to open up, including one which we'll return to, namely how to extend rights beyond human rights to rights that could be possessed by mammals, other species, the environment as an abstract, or could we construct ways in which environmental protection could be advocated for, perhaps by an invention, a kind of legal creation, a trustee, a guardian ad litem type person. We have all sorts of examples of legal constructs to help represent ideas and to do justice to situations where the person affected cannot speak for themselves. And I remember those classes being incredibly creative and interesting around those themes, but I didn't think that ecocide was the best way of getting at them then. And in a career trying to use legal arguments to deliver outcomes, to be very focused on how the law can be transformative, how the law is in some sense a reflection of our will to perfect ourselves, something beyond our own capacity to organize, to self-organize, something you put into your constitution, the way in which the law is capable of expressing our best aspirations for ourselves. And when you place that in the context of the very significant threat that we have created in a system that is so much more powerful than ourselves, the natural environment, and where we are very literally at risk, then it does seem logical to ask harder questions about how our legal system could protect ourselves from ourselves by attributing duties to that natural system upon which we depend for our survival and prosperity. So I've started to think more about how that original idea of polis, now taken forward by the enterprise that Philippe already referred to, and this new commission that Philippe is a part of, how does that work in the context of some progress in the creation of international environmental law, but not enough? And where there is a movement, particularly a movement of the youth, that is looking for an outlet for perfectly justifiable rage, for righteous indignation that needs direction, for something that will not be satisfied entirely by existing political forces, because their movement doesn't fit naturally in existing political forces. In fact, one of the reasons why it's so energized is the frustration they have with political processes. And actually, this is partially a response to Geoffrey's question. I am concerned that that movement doesn't have enough outlets for their rage. It isn't adequately directed. And it does seek redress. It wants justice. It calls for justice in the language of the law. It might be articulated in a more kind of discursive way or a more general way than a lawyer would normally wish to see, but that is how they express themselves. They want climate justice, and they're not satisfied with what is presented to them. So in that sense, ecocide provides some language for them, some process for them that could lead to an outcome that would satisfy that clamor. And I do think we are invited by it to think more creatively about how the legal order could give effect for that desire to see the environment adequately protected in law, and the pieces of environment that are most vulnerable to climate change, for example, given expression in the legal order. And you can do that. You can do it with the concept of natural capital too. That's interesting as a parallel theory, more obviously manifested in economics. But still, if you have a concept of natural capital and you ask yourself, how might I protect natural capital in practice? You inevitably are going to need the law. You'll need rules, you'll need disciplines, you'll need requirements for disclosure for investors. You'll need your infrastructure bank here in the UK to have a mandate for natural capital. You'll need the World Bank and other institutions to have a mandate for deploying public money to enhance natural capital. Well, that's not so far removed from the concept of ecocide, creating rights in the protection of the environment for its own sake, not simply for its utility to humans. And I can see some opportunity to be creative about what institutional voice could be created for this abstract idea. And that's why I think it's quite useful to go back to quite well-established concepts like trustees, advocates general, guardian ad litem, ombudsman. These are all ways in which one could give effect to the definition that Philippe has described, which actually I think is much more useful than the idea of ecocide is. I think if you combine the idea with something, with that definition, I can see it being implemented into a legal order, thereby creating procedural rights to courts and tribunals, not just hanging all of our hopes on the ICC to come up with something that could be actionable there. But finally, there, at least, you can hold up the kind of most egregious abuse of power that would require that tribunal to be used. You know, and I'm afraid I can imagine leadership being as crass as to deliberately harm the environment. I'm afraid I can. I can certainly see all sorts of trade-offs which are uncomfortable to approach between certain types of economic development and catastrophic effect, irreversible effect on the environment. And I also can imagine that if you had such a criminal sanction associated with a criminal law at the international level, it would act upon the minds of some of the most abusive leaders who care little or nothing for the effect of their decisions on the natural environment, which has consequences beyond their shores. So there's a very good reason for having international law take responsibility for this argument, because the kinds of concerns that we have about the global environment are never adequately addressed by a single nation or decisions made within a single nation. You will need some kind of international jurisprudence and the capacity to implement it as well. So I think I'll leave it there and be available for further questioning, but I've come to the view that the idea is ready to be turned into something that is implementable in a legal order. The legal order will be attractive to those who need their voices heard and acted upon. And we see signs of it in a whole series of constitutional cases in recent times. Ireland comes to mind, Germany, several other cases where the rights of the child have been expressed, intergenerational equity is in play. And those arguments are, again, close by the ecocide argument and the definition that Philippe and his colleagues have put together. And I see a real value in that kind of advocacy.
James, thank you very much indeed. Before I turn to the written questions that are coming in, given that all 220 of us on this call will have shared a common experience of listening into COP26 and hoping it was going to work, can you tell us what those power brokers there, insofar as you discussed this with them, thought of this as an idea?
Well, the particular question of whether or not to adopt ecocide is not a central part of the negotiations in Glasgow. But 100,000 people turned up to march in the streets, and on Friday was largely driven by, if you like, children. Right? It was a youth march. And you saw signs up in that march referring to ecocide. And you definitely saw a clamor for climate justice, which is a phrase that embraces several of these arguments. Some of it is intergenerational in character. Some of it is to do with those most vulnerable to climate change and least able to respond. In fact, the work that Philippe and I did all those years ago was for those most vulnerable nations. And we helped to form the Alliance of Small Island States. And that's still, that organization, that group of most vulnerable countries is still effectively the conscience of that process. You see this in every COP, that the Small Island States play a very significant part in getting the agreement to be the best it could be in all the circumstances, all the compromises, all the trade-offs that more powerful nations make and sometimes in a way that limits the effectiveness of the agreement. So you won't get a clear line drawn between Philippe's work on ecocide and the outcome of COP, but what you will get is a very clear representation of a strong movement of ideas that demands action on climate and is looking for a way to deliver that. We had in the first week, very deliberately, it was organized as such, a series of kind of drumbeat announcements on forests, on methane, on finance, on coal. And the ideas look compelling, but they need to be backed. They need to be endorsed, and also implemented by structures designed specifically to do that, to do the delivery after the big statements of intent. That's work to be done. And I do see these legal arguments as being companions.
Well, James, let's move to the first written question. Lauren BB was first in, and I think her question in a way chimes with your observation about the crassness of leadership, or the crassness of leaders, because she asks, is it envisaged that a crime of ecocide would work with convicting governments or individuals? Would one be more effective than the other at protecting the environment? I see that Philippe has probably read it while you've been speaking, so perhaps Philippe, what's your view?
Thank you, Geoffrey, and thank you, Lauren, for your question. Yes, I should have been clearer about this. So our terms of reference were to propose an amendment to the statute of the International Criminal Court. So in our work, it was a given that we would only be concerned with crimes committed by individuals, because as we all know, the ICC only has jurisdiction over individuals. It doesn't have jurisdiction over governments. It doesn't have jurisdiction over corporations or NGOs or associations. So in drafting the text that we did, we focused on that approach by the International Criminal Court, and we didn't try to second guess it. There is quite a lot of work being done on trying to expand the jurisdiction of the ICC. My dear friend Andrew Clapham in Geneva has done a lot of work on corporate criminal responsibility at the international level. For my own part, I think although there's a nudge in that direction, the ICC statute is not going to be amended. And I've got to say, I don't think it needs amendment in that regard for this reason. Individuals include individuals who happen to be government leaders or chief executives. That doesn't get you off the hook. And just as at Nuremberg and at the Yugoslavia and Rwanda tribunals, the individual who wears a particular hat doesn't cease to be an individual because they happen to be a minister or because they happen to be a CEO or chief operating officer of a corporation. So the focus on individuals is perfectly capable of working its magic, so to speak, to exercise the minds of any human being potentially in any place. I've got mixed views about corporate criminal responsibility at the international level. I mean, you can't lock up a corporation. You can fine a corporation, but I really don't think at this stage of things that fining a corporation for harm to the environment, I mean, it's neither here nor there. It's not going to act, frankly, as a disincentive. If you really want to disincentivize, the idea that someone who takes a decision which is going to have these kinds of consequences, authorize a new oil field without a proper assessment, or countervailing measures to limit the consequences for the climate system, or various other consequences, I think that is good enough focusing on the individual. When we published our work in June of this year, I got inundated with interview requests, and it was interesting. It wasn't just the usual suspects: Wall Street Journal, Financial Times, financial newspapers, corporate newspapers, very interested in asking. And I did a couple of interviews. It was very interesting. The one with the Financial Times, which you can go and see online, a journalist, very good journalist, pushed me and pushed me and pushed me. She wanted names of individuals who could be caught by this. And I resisted for the same reason that I said earlier. The moment I put a name out there, I've got an opponent, and that's what I need to avoid doing. So she said, would you mind if I came up with names? I said, well, no, it's up to you. You want to write an article about it. I can't stop you expressing your free views. I mean, I'm also the president of English Pen. It's hardly for me to tell people what they can and cannot write. She can write whatever she wants. So she did write an article in the FT, and she identified two individuals. She identified President Bolsonaro for his current efforts to not protect the Amazon. And she identified the chief executive officer of ExxonMobil by name. And what I have learned from my sources in that company is that he was not well pleased to be identified by name, because he has children, he may also have grandchildren, and future generations and younger generations really care about this stuff. So I am not too bothered that the focus is on individuals, but I understand that there is a decent argument for the opposite. What I always come back to is what Lauterpacht put in Hartley Shawcross's speech, closing speech at the Nuremberg trial. International crimes are not committed by governments, they are committed by individuals. And he's right.
Before I come to you, James, on this, can I make one observation and then pick up, particularly on the corporate liability point, which is the subject matter of the second question in part from Marie-Amance Renaud. But I so agree with the point that law can change behavior, and indeed not only behavior, but ultimately the way we think. And you only have to think of our own conduct in things such as drink driving, but it happens slowly. And I'd like perhaps you to think about that. James, on the question of corporate liability, what, if anything, would you like to add to what's already been said? And you probably read the second question already.
No, I'm very much with the Lauterpacht quote is ideal. That's the right way to focus this conversation anyway. There are lots of ways to get at corporate liability, and I'm certain that there will be many, many more cases, certainly in the climate field, looking at the decision-making of corporations and the consequences of their decision-making in respect of climate change. And much of that will be to do with misleading information, reporting to markets. A lot of the interventions are going to be quite technical. I know there's a lot of funding being organized around those cases. So I think there'll be many different routes to liability and responsibility that will go after those who make decisions in the corporations. And I'm content that this argument be focused on individuals. Now, you're right, we have a problem with time. I mean, you said it initially, Geoffrey, we really do. And we feel it, having been engaged with this process for over 30 years. I have a sense that when change of consciousness happens, it happens quite fast, actually, after a long build-up. You can see this with attitudes that shift, because movements of ideas can occasionally get up such momentum that they become exponential. And something that takes a very long time to break through becomes blindingly obvious quite quickly thereafter. You could think of the situation in a country like Ireland and how quickly they went from illegality in various sexual relations to legalizing same-sex marriage. That happened very fast, but after a long build-up and a long history of injustice.
But James, that was not as a result of criminal prosecutions and alleged or identified crimes changing the way people think. That was as a result of social changes and legislation and political influence. And
yes, but arguments were couched in the law. That's why I wanted to pay particular attention to the clamor for climate justice. That's an argument made in law in a very political context. But there were people who had suffered from the injustice of the laws, both legal, secular and spiritual, religious laws in Ireland, who've been on the wrong end of that process for a long time, who were able ultimately to break through. I'm simply saying that that was an example of changed consciousness. It had many elements that had to coincide before the change actually happened and was reflected in the law. And I do think there are cases, we know there are cases where the legal action comes ahead of the change in politics. In other words, there's some reason for these arguments about justice to become more visible because of a case. Even if you're not successful at that moment, you may influence the politics that in turn changes the rules of the game. That happens. Sometimes the sequencing is different. And I think in this case, you could see some of the constitutional cases. I think you could argue, actually, again, using Ireland, I think the constitutional case in Ireland helped the change that has taken place now, albeit with a coalition government that involves the Greens, fundamentally altering the legislation on climate in Ireland. But the constitutional case came before the change in the law.
Let me just carry on with being a little bit awkward, if I can, by picking up Fiona Gilmore's question, because it's a neat and short question. She says, I support ecocide and the need for international law to help protect us from ourselves. Does the choice of the word ecocide and its particular meaning devalue the meaning of genocide? And to that, I'll just link this. If you're looking at crimes for changing the way people behave, and I'll ask the question rather than give the answer, is there any evidence that genocide trials has actually stopped a génocidaire in waiting? Perhaps Philippe.
Thank you, Geoffrey, for that double whammy. Well, let me, it's interesting. I get that question quite often. It's very interesting that I fear that somehow if we start focusing through the criminal law at the international level on the protection of the environment, we make the killing of human beings in large numbers as a group somehow less terrible. I have trouble seeing that personally. It's not a league table. It's not either or. The fact that we have domestic criminal laws in relation to certain environmental harms doesn't in any way diminish the crime of murder. And I think that the question, and this is not a criticism at all, reflects this sentiment that has grown over the last 70 years that is a very complex thing to explain. The way genocide has just gone to the top of the pile as the sort of crime of crimes, as some people call it. To my mind, if you kill 100,000 people as a crime against humanity, that is no less bad than killing 100,000 people as a crime of genocide. This obsession with putting labels on things really worries me. Why is it that when an American president says a genocide is happening in X or Y, it's on the front page of every single newspaper? But if an American president says there's a crime against humanity happening in X or Y, the newspaper just doesn't cover it at all. Now, is it because human beings somehow feel the killing of other human beings as a group is more terrible? Or is it that just this magic of this word invented by Lemkin, genocide, evokes horror of a kind in the imagination that goes beyond other kinds of horror? I don't know. I suspect it's something to do with that. I know, and you again know this better than I do, much better than I do, Geoffrey, that victims get very irate if their perpetrators of the crimes against them are only prosecuted for crimes against humanity rather than genocide. I mean, there will probably be another war in the Balkans because the Croats only got a crime against humanity and the Bosnians got a genocide. I mean, honestly, you know as well as I do that this is a subject people talk about over there. So that there is something about this word genocide that gets people incredibly agitated. And that is why, and it may be a problem, that the use of the word ecocide is intended to elevate in a way that may cause some to feel, this is a problem. But personally, I don't see it. It's a way of signaling that massive destruction of the environment is something prescribed by in international law. Remind me of the second bit of your question. It's just fallen off my brain for a moment.
It's probably fallen off mine as well. So if somebody can't remember it, we'll come back to it when somebody can. But I think
James has got it, I think.
Yeah, I also want to make a link, because part of the justification for making the ecocide argument is that we have got to a stage where we as a species have so influenced the natural environment to such an extreme extent that we as a species are both vulnerable to its destruction, and we are causing other species to disappear at an alarming rate. So this awareness of our responsibility to other species, and at the same time, the risk that we are causing to ourselves as a species, requires an intervention that is of the size and scale and magnitude of this idea. And if you are making decisions, whether you're a politician or a leader of a corporate entity with significant power, or frankly, any other association that is capable of making a significant impact on the environment by your decision, then these are the sorts of risks that we are now running. This is the scale of our capacity to change the natural world. And therefore, we ought to have a commensurate crime associated with those acts, which we do need to prevent and punish. I think it's that straightforward, except that it's quite hard to do in practice, but it is an argument that can and should be made.
Time is running, and I'll try and remember the second part of the question, Philippe, but picking up on Philippe's really important point about the sense of disappointment of victims makes Sam Gibson's question quite interesting, because he says, what difference will the introduction of ecocide as the fifth international crime make when the biggest polluters are not states parties to the Rome Statute? And further, does it risk continuing the non-participation of those states to the detriment? Well, let's just narrow that down, because for many, victims are under-considered. They're at the bottom of priority piles, despite what you might expect. And this proposal would leave out of account all the victims of all the non-states parties. Quite a big question. Who'd like to go first?
Yes, I mean, I do want to go with this because this is actually terrifically interesting. Firstly, can I just say, and this has been the same with every webinar, Zoom type thing on ecocide, we're used to the thing that as you proceed, as you get ever deeper, the numbers drop off, and they drop off pretty quick. There's no drop off of numbers. There is something about this subject that chimes with people's current needs and hopes, and that is very interesting. So this is fascinating, and I must confess that in the working group we really did not turn our minds to it. It is only since we produced our report. Many people on this call will be aware that the jurisdiction of the International Criminal Court only extends to, well, in the absence of a Security Council determination, to a situation in which the perpetrator is a national of the state, or the crime takes place on the territory of a state which is a party to the Rome Statute. And that's the basis, Geoffrey, for your question. Now, one of the things James and I are keenly aware of is that environmental issues don't sit neatly within national boundaries. So a person in country A may do something absolutely awful, the consequences of which are felt in 73 other countries, some of which may be parties to the statute of the International Criminal Court. Query, does that bring the jurisdiction, does that imply jurisdiction of the International Criminal Court for the consequences felt outside the territory of a non-state party, on a state party? Now, as you all know, Geoffrey, in November 2019, the International Criminal Court had occasion to deal with this issue. It faced a situation in which refugees fleeing Myanmar onto the territory of Bangladesh ended up in refugee camps in Cox's Bazar. Myanmar is not a party to the statute of the International Criminal Court, but Bangladesh is. And so an investigation was commenced by the prosecutor's office on whether they would have jurisdiction in relation to elements of the crime against humanity that was committed not on the territory of Myanmar, but on the territory of Bangladesh. And the theory behind the case was that the inability of the Rohingya, members of the Rohingya community, to return to their homes in Myanmar without just cause was part of the crime of deportation and a crime against humanity. And 3 judges in a pretrial chamber of the International Criminal Court said, yes, we have jurisdiction over that. That decision, in effect, opens up the possibility that a major act of pollution taking place in, let us say, hypothetically, China or the United States, which is felt on the territory of a state party. And here we get into the climate change paradigm, absolutely, could actually fall within the jurisdiction of the International Criminal Court. I mean, this is a complex and interesting issue that you've raised in this question. It's a superb question, like all of them. And I think it requires very considerable thought. I think the answer that has to be given is that any particular case, as with the Rohingya case, will have to be determined by initially the prosecutor's office, who will then have the burden of persuading a pretrial chamber that there is a plausible basis. I can see that the Rohingya decision is not free from difficulties, shall we say, but it has been celebrated by many people and not celebrated by others. But I think it's more complicated than simply saying, oh, you're not a state party. Plus, you know, a lot of the actors that are engaged in these enterprises that cause massive harm are global conglomerates. They don't exist only in a single country. And this opens up all sorts of possibilities. So the idea of a world in which, you know, we're neatly divided into 200 sovereign entities is simply disconnected from the global ecological reality. And the International Criminal Court maybe at some day will have to face that tough challenge.
Philippe, with limited time, I must give James a chance on this as well. But thanks to Charles Littlewood for remembering that which you and I had forgotten, that the question was, has making genocide a crime actually prevented a would-be genocidaire? But James, on the question of the limited reach of the Rome Statute geographically, would you like to add to what we've heard from Philippe?
Well, briefly, because there's other things we need to get to and not much time. So briefly, look, first, Philippe's exactly right. The nature of these global environmental problems really stretches at our capacity to use, if you like, traditional sovereign state to sovereign state international law. I mean, it really does examine the limitations of that way of thinking about international law. It means that we need to be much more aware of the capacity of this argument to itself be a way of rethinking who might bring a claim, where they might bring a claim, on what basis might a claim be founded, given that so many of the issues we're most concerned about are either transboundary, or they're to do with a single atmosphere, or they're associated with the loss of species and the diversity of species upon which we all depend, even if it's only happened in one jurisdiction at a time.
Can I interrupt you just because first of all, we are probably out of time. I'll see if we're being allowed any leeway. One of my questions was to both of you by email, should the individual citizen have access to this court process, or must it be limited in the way that the present ICC is limited? And before I shut up, you said there are things left to be dealt with. In whatever time we've got, tell us what they are and give us a summary answer.
Okay, so let me have a go at this. So I do think we should be being very creative about the sort of access to justice part of this story. And we should be figuring out how claims could be brought in ways that are not simply dependent on the kind of ritual of sovereign state to sovereign state legal action. So I'll leave it there, but it's essential that we really examine how you might be able to bring claims forward in a structured and ordered and disciplined way, arguments in law before international tribunals that have the consequences of calling to account the abuse of power, including sovereign power, subject to the rule of law. We should be thinking about how we might do that. What devices, what intermediary could we construct to make it possible to apply ecocide in practice and not have this dependent on some kind of ritual sovereign state versus sovereign state, number one. Number two, I am very interested in how the concept of ecocide could find its way into other jurisdictions. And Philippe mentioned the progress already with jurisdictions thinking about this, making it part of their national law. I think it's possible that other tribunals, apart from the ICC, might think of ways of using their existing jurisdiction to pick up elements of that new definition, which I think is quite a useful one for applying in other areas. It may not be a criminal sanction, but it might be very close to some other area of law in international environmental law that could be applied in other tribunals. So I think the role of arbitral tribunals, the role of existing courts and tribunals that have other legal bases might be looking across at ecocide and thinking, you know what, that's quite relevant for what we do. And final point is that I do think it's proper to see this as part of more general advocacy, that it has a role in this shift in consciousness that we've talked about already. It might find an outlet in some other way. We don't need to put all our hopes and dreams on the statute of the Rome Statute. You know, I think that's one place to take the argument, but I think it's something more profound is happening in the way the claims are being made, in the orientation of the arguments. Who is it aimed at? Who's behind the claims? That should challenge us to think of ways to give expression to the clamor for climate justice. And I think ecocide goes into that space and should be thought of as another form of argument that's supposed to correct egregious and damaging behavior done by those who hold power.
Before I possibly offer Philippe a last word, so Guy, Master Treasurer, having done your job of filling in for the late arriving moderator, doesn't mean to say you won't have a question of your own and hold the clock and say when we've got to shut up. So A, do you have a question? B, can Philippe have a couple of minutes to finish? And then do you want to say thank you?
I'll certainly do the latter two. I don't have a question, Geoffrey. I've been watching them come in on the Q&A and I've never seen such first-rate questions. I mean, this is plainly an audience that is right on top of these issues, so it's a pleasure to see. But if there's one last out there that we can squeeze in, I'd far rather that were put to Philippe and James than anything from me.
Well, let's give Philippe the same chance that I gave to James of a couple of minutes to raise issues he thinks we may have missed, and I'll see if I can find one short question then to ask both of them. Then we'll hand over to you. Philippe, what do you think we've missed out so far?
We've missed out responding to your second question, and we have to honor Charles Littlewood, and I have an answer. Has genocide been remotely useful? Hirsch Lauterpacht took the view that it was a completely useless concept, and that was why he was opposed to it. Impracticable, incapable of determination by judges, and would have not the blindest effect on the reality of life. I'm not sure that that is the case. As you know, I have a certain skepticism about the concept of genocide. But recently I did have occasion to be involved in the case brought by the Gambia against Myanmar, where an application was made for interim relief, injunctive relief, before the International Court of Justice. And it was interesting what happened. It caused a hearing to be held in The Hague in December 2019. a massive amount of press attention, catalyzed in part, but not exclusively, by the curious decision of Aung San Suu Kyi to turn up in court and defend her country's honor. But what I am told is that although it has not stopped all of the horrors, the spotlight in the court of public opinion has had some consequences in, should we say, taking the steam out of certain actors and making certain individuals associated with the government of Myanmar's machinery, should we say, a little less eager to post things on Facebook and do other things. So I can't prove cause and effect, but I'd be surprised if it hasn't had some consequence. I do know also from my own practice that the crime of genocide and fear about indictments for the crime of genocide has caused certain individuals to stop traveling. It happened to President Tudjman of Croatia, who was so anxious about the prospects of being, or the possibility of being indicted. You will know a lot more than me about this, Geoffrey, that he declined to travel, even though he was seriously ill, and he probably died earlier as a result of that. So there is some evidence that it concentrates the mind of others, and it becomes part of the conversation. And it does have dramatic consequences. Let us not forget, and this, I did an event for the Bar annual conference a couple of days ago, and I made the point that the fact that 4 members of the English Bar wrote an opinion a few months ago articulating the possibility, and I've read that opinion with great care. It's a very carefully drafted opinion on the facts, on the law. It reaches conclusions which are hesitant but open up the possibility that the treatment of the Uyghurs in China may be a crime against humanity or even a genocide. As a consequence of that, the Chinese state has come down on not only those 4 barristers, but the barristers' entire chambers, and sanctioned the entire chambers, causing mayhem in that chambers. So there are consequences. And I said in the conference on Wednesday, I was deeply concerned that the government, the Bar has spoken out very, very strongly about this, but the government has simply not done enough to protect these 4 barristers and the chambers from simply engaging in their professional responsibility of being asked by a client to prepare a legal opinion and making that opinion available. So there are consequences to acting in relation to genocide, and there are consequences in relation to expressing views as to whether or not a genocide is or is not occurring. Ditto for crimes against humanity. My final comment, and there may be room for another question, very happy to do that, is this is a remarkable audience, as Guy has said, and I'm sure it's a very young audience. It's your generation's right and responsibility to run with this issue. Please pressure us of the older generation to do the right thing. We have left things in a mess, and we have a responsibility to help clean up. If you care about this issue, get stuck in, because your engagement, whether in a professional capacity, in a personal capacity, in a political capacity, will make a difference. Governments are listening and they do respond to pressure. So if you care about this, as I hope you do, please act on that expression of belief and hope, because I think you can make a difference.
So taking the Treasurer's offer, perhaps, gentlemen, you can answer Ed Smith's question, which is itself quite short, quite shortly. The first point is factual and the second is commentary. Did the working committee consider, when formulating the definition, whether ecocide may be misused by others to justify violent acts or terrorism when alleged acts go unpunished in the eyes of some people? Can the definition head this risk off?
We, Ed, did not address that issue. I can see the logic of the question, and there are here interesting interplays between different international crimes or potential international crimes. We were very anxious in our work to set the bar very, very high in our definition. And that's why we set a double or even triple threshold. There is a lot of environmental harm occurring. There's a lot of serious environmental harm occurring. And we were very concerned to set the definition at a point where it has to be, if you like, of global interest in order to engage the jurisdiction of the International Criminal Court. Now, some such acts do generate strong feelings in certain people who go out and do things that on some occasions include the use of violence or possibly even acts of terrorism. We didn't discuss it, but I think the view would clearly be that one international crime being occasioned does not ever justify another being committed, but we didn't discuss it.
James, anything to add?
It is the case that a lot of so-called defenders of the environment are at risk. There are many people who have fought to protect landscapes, forests, various ways in which environmental campaigners have been brought right up against really strong use of force in some countries. And I think that most of the problems on the other side of that equation. But it's equally true that one of my concerns is that if we don't find ways to channel and direct some of this fear and anxiety as well as anger, it will be manipulated. It will be taken towards ends that will cause real harm. And I think the law's got a very important role to play there too, in providing clear pathways to rational, evidence-based argument that has a strong moral element to it. And we can do that with a claim like this in this context, even with a very high bar, and with loads of other ways of registering an argument for climate justice available to people. I think the law could be used productively to create obligation, to enforce obligation, to create spaces in which science and technology are discussed alongside moral outrage, and solutions are more likely to be found when the law is providing some rational pathway for solutions to be found. That's what I'd hope anyway. James
and Philippe, thank you very much for allowing me to be part of this, as it were, or rather Kate allowed me to be part of it by letting me get in. Before I hand over to Guy, just two things. I've learned a great deal, and in many ways I'm heartened not just by your optimism and the history you set out, but as you've both, I think, referred to, and Guy already, by the level of interest and the nature of the questions that have been asked of you. Guy.
Well, I think the audience will appreciate the astonishing thing about this evening, that the time is absolutely ripe, isn't it, with COP26? You, the speakers, are absolutely right too. I mean, for heaven's sake, we are spoilt with the pair of you, Philippe and James. What better pedigree can speakers possibly have to come along and address this topic than the two of you? I mean, it's really quite humbling. And the fact that you were so nice and human about this was quite deceptive, really. I mean, you are absolute titans in your field. And then you, Geoffrey, it's not just the Uyghur Tribunal that you are absolutely renowned for. I mean, your own part in this field goes back a very, very long period of time. And what's remarkable, and everybody should appreciate this, is that you are the originator of this social context of the law series, and how utterly brilliant it's turned out to be. My own thoughts lastly on the topic we've been addressing. Yes, I think genocide is difficult to apply in practice as a concept, but that's not really the point. I think the point about the invention of the crime of genocide is that it dignifies the human spirit. It's all about the good guys, isn't it? Recognizing that something must be done. So too, I think with ecocide, I'm not in a position to share your confidence, Philippe, that this will be on the statute book fairly soon. But it is a remarkable statement coming from an experienced barrister like you. And barristers are famous for havering and being diffident and sitting on the fence in their opinions. And I am absolutely reassured and delighted by your statement as to the future. And let's hope it's not too long coming. Well, ladies and gentlemen, generally, thank you for supporting this. I've absolutely been excited by this evening. It's been absolutely terrific. And I think it just remains for me to say thank you to Inner Temple, to Kate and Rosie and Henrietta for putting this on. And that's probably it. So good night all.
Good night. Thank you very much.